So we have envisioned this panel as a way to expand out the vision of the battles going on over abortion in courts around the world, and have included Judge András, who is a retired judge of the European Court of Human Rights, where he was vice president, and he served from 2008 to 2017. He is currently a university professor at the Central European University in Budapest, where he was the founding dean of the law program in the early 1990s. He was educated and lived in Hungary under communist rule, and during that time he founded the League for the Abolition of the Death Penalty, which was instrumental in the abolition of the death penalty after the collapse of communism. He participated as an expert in constitution drafting in 4 countries in the early 1990s and served, including South Africa, I believe, and served as legal counsel to the first freely elected president of Hungary. Judge Sajó has taught extensively in the United States, including at the University of Chicago, Cardozo Law School, NYU, and Brigham Young University. His publications focus on constitutional theory and comparative law, as well as socio-legal issues. And his current research, which is absolutely fascinating, focuses on the demise of constitutionalism. And he's also, we're very fortunate to have him as a visiting professor at Harvard Law School this year. So welcome, Judge Sajó. And we want to continue the discussion from the first panel. And this, although this may seem very basic, I think it's worth setting out explicitly, because the opportunity structures for courts depend largely on the normative universes that they draw upon, the institutional mandates and capacities, and the procedural postures that the cases are brought to them in, which was referred to in the first panel, but I think we're going to explore it just a little bit more. So in the context of Mexico, the role that federalism played, both in terms of the origins of abortion in the Mexico City case, and also the challenges to it, was mentioned quite a bit. And I was wondering whether either of you could comment a little bit more on sort of the evolution of how the court has managed to deal with states' rights over the course of these years, and possibly also the influence of the 2011 reforms and the different relationship with international human rights law.
Well, I think that we were, I think it's worth mentioning more the 2011 reform and the 2013 reform to the Ley de Amparo, which I think a lot of the cases we're seeing now are directly related to that. In 2011, we had a major reform of our Constitution. It established in the Constitution human rights, and we abandoned the concept of civil liberties. And Article 1 of the Constitution established that that in Mexico, treaties that contained human rights had the same level as the Constitution. And we debated a lot about what that meant and how that meant, and eventually we got to the point where we concluded that it was very similar to the U.S. incorporation doctrine, where we incorporated into our Constitution all treaties that have human rights. And that had a tremendous impact on how judges decide cases in Mexico. These issues sometimes seem a little nuances, but when a judge has to confront a case and he has to cite constitutional law, and he doesn't have to just cite constitutional law, but he has to cite treaty law, and treaty law will invalidate because it's at a constitutional level, secondary laws. Then you have judges having, even if their personal beliefs are different, they have to dialogue and discuss with treaty obligations which Mexico has entered into in the human rights field. And that really expands the way a judge can see and decide a case. And that's been fundamental with gender issues, it's been fundamental with health issues, and it's been fundamental because those rights have always been in the Constitution on a social level. Usually, for a long time, they were seen as non-justiciable, and now you're really starting to see judges and circuit courts discuss these issues in their adjudications. Another important issue is the amparo law. Before, we had very strict procedural rules, like I mentioned earlier, on standing, on ripeness, on moot. And the new law really abandoned the old criteria, and that's allowed a lot of people that would normally not have access to courts be able to have their cases heard in courts. And obviously that has an enormous impact on sectors of society that have been historically discriminated against. And it's really opened up the floodgates. And I think that's why you're starting to see now a lot of issues that before it would be very hard for them to get to court. As to the federal state issues, I think that's starting to change. I think most of the judges today would probably find a constitutional right to abortion. We just haven't had the case yet that has gotten to the court. It'll come eventually, but I think right now the mixture of judges would probably, and I don't want to speak for anybody else, but I think they would probably find against a state issue on abortion. The case I described today was issued, and I think I should have explained this before, by a panel of 5 justices. The way the Mexican court works, we can sit in banc all 11 justices, or we can separate into 2 5-judge panels. This was one of the 5-judge panels that decided the case unanimously, I think. And we still haven't gotten a case where in banc we confront the issue of whether there is a constitutional right to abortion. But I think the votes are there.
Would you like to add something? Yes.
Tenemos que ver que México ha cambiado mucho en los últimos años.
We need to consider that Mexico's changed a lot in the last couple of years.
Hace 50 años el sistema de salud mexicano era bastante primitivo y deficiente.
50 years ago, the Mexican health system was pretty primitive and deficient.
La política internacional obligó a los estados como México, América Latina en general, a restringir el crecimiento demográfico.
International policy required that Mexico and a lot of countries in Latin America restrict demographic growth.
A partir de la presencia de McNamara en el Banco Mundial, se condicionó la posibilidad de obtener préstamos a restringir el crecimiento demográfico.
With McNamara and the World Bank, we were able to get loans to be able to restrict population growth.
La preocupación de los países poderosos económicamente era el peligro del crecimiento demográfico.
The big concern of the powerful nations was the population growth of other countries.
Fue entonces cuando se planteó la necesidad de educar a la población, de facilitar el control natal y de fomentar en cierta medida la decisión de las mujeres a que si querían tener o no una descendencia más numerosa.
This is when we began to consider access to birth control and whether women could start to consider how many children they wanted to have.
La política internacional, debemos de recordar el caso de China, que era una familia, un solo hijo para reducir su crecimiento demográfico.
We have to remember, for example, in international policy, China's one-child policy.
Y aunque los estados, como los estados mexicanos, los estados de la República Mexicana, no aceptaban la reducción de la población a través del aborto,
And even though Mexican states did not allow for the restriction the restriction of population growth through abortion,
la cantidad de mujeres que perdieron la vida al tener que practicarse abortos llamados clandestinos hizo que las autoridades reflexionaran de la necesidad de que el sector salud proveyera ese servicio.
the number of women that were losing their life due to clandestine abortions led the health sector, the Ministry of Health, to have to think about how they were going to protect these women's lives.
Y hemos pasado de unas posiciones radicales que impiden que se practique el aborto, por lo menos en las clínicas públicas, a una posición en que facilitan las clínicas públicas la interrupción del embarazo.
And we've moved from a radical position where public clinics were not allowed to provide abortion to public clinics facilitating access to safe abortion.
Se convirtió en un problema de salud pública el cómo proveer de los servicios de una forma lo más sana para la mujer.
Therefore, it became a public health problem of how we could provide these services in the healthiest way possible.
El esquema internacional, los cambios que se vinieron dando en Europa, principalmente en los países de la Europa que no estaban tras la cortina del hierro, de hierro, porque ahí sí se facilitaban la interrupción del embarazo, hizo que se replanteara políticas públicas como en la Ciudad de México, la más poblada, que permitiera poco a poco estos cambios legislativos.
Changes in European policy, particularly countries that were on the other side of the Iron Curtain, because on the eastern side of the Iron Curtain, abortion was legal and accessible, allowed for places like Mexico City to be able to reconsider their abortion policy.
La Ciudad de México y Oaxaca son las dos únicas entidades, como nos decía el ministro Alfredo Gutiérrez, que permiten la interrupción del embarazo sin penalizarlo.
Mexico City and Oaxaca, as Justice Gutiérrez was telling us, are the only states where abortion is allowed without, where it's not penalized.
Podemos ver qué tan dramático es la situación en las comunidades en donde no existen los servicios de salud que permitan a las mujeres obtener ese servicio.
We can see how dramatic the situation is in communities where there are no health services to enable women to access the service.
So I want to now turn to you, Judge Sajó, and to a very different context and a very different tribunal with the European Court of Human Rights. And perhaps you can just say a word about, it's an incredibly important, for those of you who don't work in Europe, an incredibly important site for the construction of rights narratives, often cited by the Inter-American Court and used in Latin America as well. And if you could talk a little bit about how it is situated in the Council of Europe, the norms that it draws upon, and as Justice Gutiérrez said, you know, they have switched to this social rights, but that's not really relevant in the context of the European Court in the same way.
Thank you. So just to give you an idea, the court deals with 47 member states, 800 million people, and after exhaustion of domestic remedies, each and every individual has the right to sue the state. That's a major breakthrough in international law, that individuals have standing against a state. But of course, this is an international court, regional one. The substantive law is limited to first-generation rights with some extensions, and that international nature explains certain limits the court is forced to accept or the court itself is willing to accept. Now, this, I think, can be illustrated in the context of choice or reproductive rights. The convention obviously has no specific language on this matter. It has language on prohibition of inhuman treatment, and that entails protection of bodily integrity in certain circumstances, and also a positive duty of the state to protect it within limits. There's a second relevant provision in the convention, right to private life, and here where most of the abortion-related cases came in. However, in a very ironic way, because the case which interpreted a right to private life as the right to self-determination and therefore a right of a woman to self-determination in matters of abortion was one that originated from Germany, where in 1975 the German Constitutional Court found that there is a certain duty, constitutional duty under the German Constitution to criminalize abortion. And this was, at the end of the day, upheld by one of the then existing bodies of the convention system. So once again, exactly in the case where a kind of right was recognized under right to private life was the one which said that yes, but this is something where there's a large margin of appreciation. Member states have a certain better understanding of what their values are. Now,
Sorry, could you just explain for the group what the margin of appreciation?
okay, so the margin of appreciation is that the states have a certain kind of discretion given their understanding of the situation, or given that they are just free to determine within limits what the scope of a right is, or how a right is actually enforced, etc., etc. And I would like to jump to another example of this margin of appreciation that, in order to help you to understand. So gradually in 43 countries out of 47, abortion became legalized, if not as a right, but at least something that cannot be stopped on legitimate grounds. So this was, for example, the case in France, where legislation liberalized abortion, and the Constitutional Council said there is no ground in the Constitution to restrict that decision of legislation. So it was not really an affirmation of a right, but much more an acceptance of a democratic decision. Again, this is the 1970s, so situation might be different today. Now let me jump to the Republic of Ireland, where the Constitution limits, or limited until the referendum considerably, or nearly absolutely, except very specific health indications, the right to abortion. Actually, it was criminalized and not possible, except because of an amendment to the Constitution, very specific medical conditions. In that case, and this will give you an idea of what margin of appreciation may mean, the court recognized that in Europe there seems to be a consensus that you cannot criminalize abortion, at least in the first trimester, etc. But then they said, as to Ireland, we will accept that that is a specific moral issue, a sensitive moral issue for the Irish society. Therefore, whatever we held as a common position in Europe is subject to exception. So because of the idea of a margin of appreciation. So there is no overall all-European judicially enforceable right as such in this context. There will be exceptions, you will see if the discussion gets there, but because, once again, the attitude of the court is kind of deferentialism or deferentialist, at least when the Irish case A, B, and C came to the court, it's moved already in this deferentialist position. The right to abortion as such was not recognized, notwithstanding the fact, as a right applicable to all European countries, notwithstanding the fact that it is recognized as part of self-determination, part of private life. But it can be overruled, if you wish, by other considerations. A right here is subject to limitations. The limitations are to be determined by the state. And here a moral consideration was enough for the European Court to allow margin of appreciation for the state. Just because I am here to give you a very neutral description, but I would like to flag that this was an extremely divided judgment of the court.
I'm just going to reverse the table tense because someone mentioned to me that we have these backwards. Very careful audience, gotta say.
So on that question, I would like to turn to you, Justice Gutiérrez Mena, and I mean, both of you have discussed how in Mexico the situation is extremely polarized. This latest judgment that configures the right to abortion within healthcare and access to healthcare would seem to impose on states, even with this condition of polarization, that they have to pay for public health facilities to allow women to access abortion, even when the local consensus is quite averse to that.
Yes. I think it makes it justiciable. I think denial of access, I think after this case, you will be heard in court, and you will probably be heard in federal court. And I think the issue there will be if the state has a right to life embedded in its constitution, whether that is constitutional under the Constitution. And I think we're setting the groundwork to have the case get to the Supreme Court. This isn't the case, but I think this is a first step getting there. And I think that's how it's going to work. You're probably going to have the denial of a service, and then you're going to have challenged, and this is going to be precedent for the challenge. And chances are it's going to be in a state where the state legislated right to life in the state constitution. So that's going to be challenged in the suit. And eventually, I think that's how the case is going to get to the Supreme Court. And I don't want to predict how the court's going to decide, but I think there's a good possibility that they will reaffirm this decision in bank. So the short answer is yes, but I wouldn't be too optimistic that there will be compliance, and it'll probably get to court and move its way up to the Supreme Court.
So Justice González Alcántara, I have a follow-up to that, which is, as has been mentioned, this protection writ mechanism, or amparo, which was significantly revised in 2013. And if you expect this to open a floodgate of cases, you know, how do you see the courts dealing with all of those amparos, and perhaps because it's a very different kind of procedure than we're used to in the United States, explain just a little bit of when those amparos go and get reviewed by the Supreme Court of Justice as well. In Colombia, where they have a similar mechanism called the tutela, Justice Manuel José Cepeda has said that the tutela forms a bridge between the Constitution and Colombian reality. And I'm wondering whether you think in some ways that the amparo can function the same way and help consolidate jurisprudence.
Desde luego, suponemos que el amparo va a facilitar el acceso a esos servicios.
We expect that the protection will enable access to those services.
En el caso que nos planteaba el ministro Alfredo Gutiérrez, tenemos el factor tiempo.
As Justice Alfredo Gutiérrez was stating, we do have an issue of time.
Cuando los servicios de salud del Estado, que tienen muchos millones de derechohabientes,
When the state's health sector has millions of people who have the right to access those services,
y en un caso concreto llega una persona a demandar esos servicios y se le niegan,
and in a specific case where somebody would access these services, would request these services and they would be denied,
y obtiene el servicio en una clínica privada mediante un costo adicional,
and if they have to go to a private clinic and pay for the service,
la resolución del ministro Alfredo Gutiérrez condena al Estado a indemnizar a esa persona de los gastos efectuados
the resolution is that the state would have to reimburse the individual because of the expenses incurred from having to pay for the service.
pero además pagar el daño moral que le causó y el daño económico que le implicó el retraso en la prestación del servicio al que tenía derecho.
And also pay for moral damage and also economic damage incurred because of delays in accessing the service.
Lo que va a obligar a todas las autoridades de los hospitales públicos a entender la problemática que representa el negar el derecho a ese derecho que tiene la mujer.
This is going to force state health sector to start to think about how they're going to ensure access to the services.
Y a través de los amparos, como fue en el caso particular, se resolvió que el Estado tiene la obligación de proporcionar los servicios.
And the protection writ established that the state has the obligation of ensuring access to services.
Y la resolución es ejemplificativa para el sector salud y para las mujeres que tienen ese derecho.
And the resolution is an example for the health sector and for women who have the right to use the health sector services.
Todo el aparato de justicia federal tiene a la Defensoría de Oficio.
The justice system has the Defensoría de Oficio, somebody can help me? The defense of public defenders.
Con lo que se facilita la posibilidad de obtener el amparo para que proporcionen el servicio.
That enable access to protection writ to be able to argue these cases.
So the move to make abortion a right to health issue and to move it into the health sector also implies some challenges. And even though it is not configured that way in the European system, some of the cases, ABC and Ireland, as well as TZIAC, confront the issues when a health system, when there are differing opinions about the severity of a health condition, when doctors are conscientiously objecting to perform an abortion procedure. So first, I'd like to turn again to you, Judge Sajó, and talk about how the European Court has approached reining in some of that discretion on behalf of the medical profession in determining rights.
So once again, there is some protection to the, not to the right of choice as such, but there's another aspect of private life which is again has to do with physical integrity. It's not a right to health in the Mexican sense or in the sense of social rights, but it's still part of private life. So there is a recognized right in that respect. And that comes in even when the state otherwise prohibits abortion. And again, the cases are coming from Ireland and Poland primarily. And the court's position is very legalistic. It's basically neutralizing the substantive issue, turning it into a rule of law procedural issue. So in case there is a authorization for termination of pregnancy on medical grounds, but this possibility, and this is required by the court, you really have to allow protection of life under another article of the convention. or physical integrity, meaning detrimental health condition. So in that situation, the court will look into the procedural guarantees to make that right to be efficient. And they will look into legal certainty. And that's basically what the court is doing. Is the legal environment sufficient to guarantee that the medical service will be provided? We never had a case where this was related to conscientious objections directly, but it's very clear that the underlying problem, for example, in Poland, that there is total lack of willingness to engage and create clear rules, or in one of the specific cases, the doctors felt unease, perhaps under pressure, so they just did not provide proper advice, they did not provide the information in due course, etc., etc. So there is an underlying structural problem, but the court does not address that. It just looks at the formal possibilities. So it's really, as I say, it's a rule of law issue for the court, which of course helps the court to avoid the hot issue. And that's where the court is. Again, it has to do with this difficulty international courts face because of growing pressure coming from member states threatening the court that they will not pay or they will withdraw, etc., etc. So that is perhaps one of the reasons. It's not a principal reason, I'm afraid.
I think that's very important to point out, that the court is operating within a larger political context. This particular opinion that you write just now, Justice Gutiérrez Ortiz Mena, has a lot of language around taking a gender perspective, and as you spoke, taking a gender perspective. It cites not only international law, but general comments, which are not necessarily binding to guide interpretation. So how important do you think it is that the Mexican court sort of name and formally declare these are reproductive rights and we are adopting this specific perspective?
Well, I think it's very important because you're framing the issue on a constitutional level again, and you're abandoning the Mexico City 2007 case where you just said it was a state issue and sort of punted the ball to the states. So I think it's very important. I also think it's very important citing international law. As I mentioned, Article 1 of the Constitution now incorporates those rights into the Constitution. So you have to address those international bodies of law. And soft law, I think, is very important also. And more the court is starting to use sources of soft law for guidance when deciding and adjudicating cases. So I think it's very important.
So I'll play devil's advocate here a little bit and say that there are some courts, not just in the United States, but even the Argentine Supreme Court, that has felt that the proliferation and fragmentation of international law, and especially soft law, makes it very difficult to cite it in a coherent way or integrate it in a coherent way into constitutional law. I don't know if you or Justice González Alcántara want to address that.
Well, I think the fact that it's not easy isn't an excuse for not doing it. Of course it's difficult, and of course you're going to have a lot of challenges, but the language the court uses has evolved tremendously. 8 years ago, if you were to present, when I just arrived at the court, citing soft law or citing international cases, we would have discussions whether we could cite to international law or not. And today, I don't think there's a single justice on the bench that would argue that we cannot cite to international law or that we cannot cite to soft law. So there's a constant evolution going on. And yeah, it's not easy. It's quite hard. There's a tremendous amount of body of law which you have to take into account. But I think that's part of the job.
Would you like to-
Sí, sí. Es muy importante este tipo de encuentros
These kinds of meetings are really important
porque nos permite conocer las posiciones de lo que pasa en otras partes del mundo.
because they allow us to see what's happening in other parts of the world.
Brillantemente conocemos las resoluciones del Tribunal Europeo de Derechos Humanos
Brilliantly, we now know the decisions of the European Court of Human Rights
y los problemas que representan la fuerza de los sectores religiosos y con los ejemplos de Irlanda y de Polonia.
and the problem of the forces of religious forces that we've seen in cases such as Ireland and Poland.
Y en América Latina encontramos el mismo problema con las resoluciones de la Corte Interamericana de Derechos Humanos.
And in Latin America, we've seen these problems in the Inter-American Court of Human Rights.
Desde luego que el tamaño de la Corte Europea frente al tamaño de la Corte Americana es totalmente distinto.
Certainly, the size of the European Court is very different than the size of the Latin American Court.
Y ese esquema que nosotros tenemos poco a poco estudiando, citando, conociendo resoluciones de países tan lejos como puede ser Sudáfrica,
And the framework that's established by understanding, studying, and citing cases that are so far away, such as, for example, South Africa,
nos permite ver soluciones que se presentan en otras partes del mundo para nuestra sociedad.
allow us to consider solutions that have been proposed in other parts of the world within our own society.
Pero aún en México, en el caso mexicano, tenemos problemas por la posición política y religiosa de las entidades.
But in Mexico, we have the problem of the religious positioning of certain states.
De ahí que nosotros, el sector salud es un sector centralizado, federalizado,
Now, the health sector is centralized and federalized.
con lo que estamos haciendo cambios a la legislación de todas las entidades, facilitando el derecho y el acceso a la salud de las mujeres.
Therefore, we're making changes in state legislation enabling and facilitating access of women to health services.
Si bien tenemos casi medio siglo de diferencia entre la resolución de la Corte Americana y las resoluciones de la Corte Mexicana,
We may have half a century between the resolution in the U.S. court and the Mexican court.
creemos que vamos en el camino correcto.
We think we're going in the right direction.
Ahora, cualquier violación es analizada por una ley federal que obliga a las entidades a interrumpir el embarazo.
Now, any rape is able to be considered by the Supreme Court as at a federal level as a lack of access to the right.
Y la discusión es muy fuerte y poco a poco iremos viendo que todos los derechos se expandan en el territorio nacional.
And this is a very important discussion, and we're working towards expanding this right at a federal level.
We've heard quite a bit, and it's really quite impressive the way that constitutionalizing these debates has transformed them. Moving from the clash of absolutes, as Justice González Alcántara started, to a more nuanced understanding of competing rights and balancing. But I'm wondering whether in the European context, you would say the same thing is happening, or whether it remains a more traditional dichotomy.
The issue of dichotomy has to be seen in its own historical dynamics. So there are cycles, and it seems to me that it may come back at this present constellation, and it has to do with a general shift in political attitudes. As to the European Court of Human Rights, the court, again, perhaps because of its position, its delicate position, was very reluctant to go for absolutes. It's always about proportionality and balancing and so forth. So one important element in not taking position is that they refuse to determine when does life begin, saying that there is no medical or social consensus in Europe on that matter. This was in a case totally unrelated, by the way, to abortion. It was a medical malpractice case. So it's very, in reality, they try to some extent to diminish the strengths of rights on both sides, except once again when it comes to the woman's right to life or health, when at least some procedural guarantees are to be in place. Otherwise, yes, there is self-determination, but it cannot be prevalent. And on the other hand, yes, there is perhaps right to life of the unborn or nasciturus or fetus, but we don't know from which point, therefore it cannot be really used as the basis for determination. If I may add one more point on indicating the difficulties also where perhaps major challenge will come. There are French cases where pharmacists refuse to hand out a day-after pill on the basis of religious convictions. It's a matter of conscience, which is protected by the court. And it was not even a judgment, just a decision saying that France has the right to deny that request or argument of the pharmacist. This cannot be, for the European Court, a genuine matter of debate as in terms of conscience. Now, there is a parallel case which was never taken up by the European Court in Germany, where most of the hospitals are under one or another church. In one of the hospitals, after a rape event, denominational hospitals, which are once again the majority, did not inform the woman who went to the hospital right after the rape about the possibility of a day-after pill as a measure, obviously, to be taken under those circumstances. Because they were obviously under instructions coming from the hospital director, who had to follow certain guidelines of the church. It was a Catholic church in this case. So this case never came to the court, but imagine with this laissez-faire attitude the court has, what are they going to say? Okay, if this is the situation in Germany, if they would like to take into consideration conscientious objection, if this is a church matter, you can restrict the right of the woman in favor of religious considerations. So in a way, with this attitude, the outcome is that you don't have a principled response to a very complex situation.
And so just a tiny follow-up on that, are you suggesting that the court would be better placed to go to the substantive issues more broadly in some?
The court did that in earlier days, in many areas, without much concern, and those judges were convinced that this is a human rights document, and human rights are universal, and in this case, they have a regional application as universal human rights. And those rights mean the same everywhere. Of course, there is a context-based balancing necessary, but that's not a ground not to be engaged in this. And somehow, for reasons I tried to explain, this attitude is less and less present in the judgments of the European Court. But in many areas, let's take legitimate children, when in most European countries there was a discrimination to the detriment of illegitimate children, other courts said, okay, there is a growing trend to, because this is a violation of fundamental principles of equality, and there is a growing trend which was not really present, relying on soft law, part of the soft law, because the other part of the soft law said the opposite. They said, okay, this is unacceptable. And this applies across the board to all countries.
I have a number of other questions, but I'm also conscious of time, so I want to open it up to questions and discussion with the audience.
I will sneak in a question if that's okay. So during the pendency of this event, the U.S. Supreme Court granted cert on a case that is almost exactly like a case it decided 2 years ago with a different court, Whole Women's Health. And it makes me want to ask about the stability of precedent in the two courts we're talking about as compared to the United States. So even if you build your ideal version of the abortion jurisprudence, do you have confidence that it will sustain, or do you feel as though changes in your court's personnel really do have the capacity to radically change course?
That is a very, very interesting question. First of all, let me start by giving some distinctions between our court and the U.S. court, because I think our stability is achieved in a different way. In the U.S. court, you have lifetime appointments, and I think that gives certain stability to certain decisions, and you have a system of precedents which is different from our system. We have 15-year appointments, so you're constantly seeing about every 2 years, 2 judges retire and 2 judges come in, more or less 2.5 years. You start seeing that rotation. So that would tend to give a bit of instability. But the way we decide cases and the way the law makes us decide cases, the Constitution, gives it a bit of stability. For example, there are 5 ways a case can get to court. 2 of them you don't have in the U.S., which is when a state or the federal government challenges a state act or a federal act, either one, on an invasion of the other's jurisdiction. And each of the states can challenge the other states, and we will decide en banc. Or a legislative minority, 33%, can challenge a law without case or controversy, and we will decide the constitutionality of the law in abstract. For both of those type of cases, for us to decide a case, we need 8 votes. And that gives a lot of stability. So that's, you're building in precedent into the system because you need 8 votes, or if you want to see it the other way, 4 judges can veto a decision. So precedents become important not because of the lifetime appointment and the slow turnover of justices, but because of the way the system is designed. So I think the precedents we set now, I'm very, very hard pressed to see a change in the political philosophy of most justices. In fact, this administration has expressly stated that it wants to balance the gender composition of the court. Right now, there are 9 men and 2 women on the court, and the executive branch has been explicit in saying that future nominations to the court, and this executive, I think, will have at least 2 more justices that they will propose women to the court. So I think that's going to have an impact on, especially on these issues down the road.
If you have a question, please do line up behind the microphone.
Thank you. Barbara del Castillo from the Mexican Consulate. ¿Qué mecanismos de difusión tiene la Corte en México para dar a conocer a la mayor parte de la población el contenido de resoluciones que son muy sensibles para la población que probablemente no tiene acceso a este conocimiento?
Sorry, just, what are the mechanisms that the Supreme Court of Justice has to educate the public and make them aware of the resolution of these issues, which are very pressing for them?
Uno de los problemas más grandes que tiene el mundo en general
One of the biggest problems that the world has in general
es la difusión de sus resoluciones judiciales.
is communicating judicial resolutions.
El lenguaje que hablamos los abogados, y aquí hay muchos,
The language that lawyers speak, and there's many of us here,
es totalmente inentendible para el resto de la sociedad.
is completely mysterious for the rest of society.
Hablamos en clave, utilizamos una terminología equívoca para la población,
We speak in code and we use language that is ununderstandable for the rest of the population.
El difundir las resoluciones y explicarlas a la sociedad es parte de la tarea de las nuevas cortes.
And it is the role of the new courts to be able to explain to society what our resolutions are.
Si bien en una primera instancia estamos enfocados a educar a los jueces y a los abogados,
Our first charge is to educate judges and lawyers,
el destinatario final es la población en general.
but the final destination is the general population.
Hace algunos cientos de años las resoluciones se escribían en latín,
Hundreds of years ago, resolutions were written in Latin
en todo el mundo.
and all over the world.
Actualmente las traducimos y las difundimos, las resoluciones explicadas para que las pueda entender una persona normal.
Now we translate that and we communicate them in a way that a normal person can understand them.
Difundimos las resoluciones a través de la televisión y la radio.
We communicate our resolutions through television, through radio,
Y así hacemos que la gente se interese en lo que estamos resolviendo.
and that's how we get people interested in the work that we're doing.
Es la única forma de llegar a la población en general.
That's the only way to get to the general population.
Si la gente siente que las resoluciones afectan su vida cotidiana,
If people feel that the resolutions affect their daily life,
entonces estarán interesadas en saber qué resuelve el juez y qué resuelven los tribunales.
then they'll be interested in knowing what the court and the judge has resolved.
Y es por eso que ahora tiene más conciencia la sociedad de la importancia de las resoluciones de las Cortes Supremas.
And that's why people are now more interested and more aware of the importance of Supreme Court decisions.
Nos preguntan cómo podemos mantener cierta estabilidad en nuestras resoluciones.
You asked about how can we maintain certain stability in our resolutions.
En ninguna parte del mundo se podría pensar en regresar a establecer la esclavitud,
In no part in the world would we ever imagine going back to slavery,
porque la libertad del ser humano es algo que hemos ganado en todo el mundo.
because we have won freedom for the individual everywhere in the world.
Por eso las Cortes Supremas, los tribunales y los abogados
That's why the Supreme Courts, the judges, the lawyers,
estamos convencidos de que lo que se resuelve es parte de la sociedad y hay que defenderla a todos.
and the part of what we decide is part of society, and we all have to defend it.
Actually, I'd just like to, before the next question, ask Judge Sajó about this, because I think sometimes we take for granted that it is a progressive conquest of rights and democracy, and we live in a situation now where in many countries, some would argue in this country, democratic institutions and democracy are facing, if not unprecedented, very serious threats. And the idea of constitutionalism and citizens, normal citizens, engaging with constitutional law and the role of law and how important it is to their daily lives is certainly does not prevail in many countries around the world. And I know you've done an extraordinary amount of work on this, so I wonder if you'd like to comment from that perspective.
So if I may add something to your formulation, sometimes these threats come from democratic institutions or distortion of democratic institutions. As to the European Court, which is probably a canary in the mine, the court, and this has to do also with precedents, the court is very much precedent or case law oriented, but the term of the judges is limited to 9 years, and for good reasons. So there is now a new generation of judges who reflect in their philosophy the reality in their own country. And they may much more interested in national values or the democratic process in their own country being the justification. So that's point number one. I don't expect major shifts in the case law, but I can envision situations where different precedents will be quoted. And point number two, that the framing of the problem will be completely different. So what is undue burden in the equivalent of undue burden here? That may be a matter for the European Court to be left to the national courts, which may have very different understanding of what undue burden is. The second element that I would like to highlight in this context is how the European Court is perceived in these 47 countries. And it's not, it was headlines that the Supreme Court of the United Kingdom, the Court of Appeals judges were called enemies of the people, and there was attack also on the Supreme Court. Now this was not very, this was a shock for British judges and people who consider the courts being a bastion of constitutionalism. It was not a surprise to me, because it was not me but my colleagues who were called by Daily Mail clowns of Europe. And that was the attitude of newspapers, because they consider, or some of them, again Daily Mail being the most influential, they consider this a matter of national sovereignty. And they are very much against the idea, and there were similar voices here in the Congress of this country. They consider that judgment rendered by so-called foreign judges has no legitimacy. Foreigners know nothing, not to speak of the superb quality, which is true, of English or British or UK judges. So why are they telling us what the law shall be? So it's a major legitimacy issue, which, of course, threatens the possibility of regional or global standards and pushes countries back to a more closed society where, indeed, the democratic process is losing one of its external, very important controls in matters of human rights. So I think that's really the stake here.
Hi, Jake Shurko at the Edmund J. Saffer Center for Ethics and here at the Petrie-Flom Center as well. Judge Sajó, you raise a very interesting point relative to something that was discussed earlier, and one of those questions relates to the persuasiveness of judgments of courts from other countries, and especially with respect to individual states in Mexico now. And so I guess my question for the justices is how persuasive are in fact the judgments of some of the other courts, especially in Latin America, where abortion is much more heavily criminalized than it is in Mexico now, given that it seems like the Mexican Constitution and Mexican society is becoming more liberal. So to the extent that they are persuasive, right, to the extent that these are important decisions to take into account, this kind of external check, as Judge Sajó was mentioning earlier, one way of looking at the decisions of courts such as in El Salvador is in fact doing the opposite of what the Mexican Supreme Court is doing now. So I'm just curious how the justices think of their role in looking at the judgments of other the judgments of other countries, especially in Latin America, with respect to this issue, which seems to be orthogonal to the direction that the court seems to be going now.
One of the things that surprised me a lot when I got to the court was just how much of a constitutional dialogue there is with other Latin American courts. It happens a lot. Colombia, Argentina, Brazil, we're constantly reading each other's rulings. We're constantly plagiarizing each other's rulings. I shouldn't say that. Citing. But there's a lot of dialogue between courts in Latin America. One of the things we were able to do with the change in 2011 between with the constitutional changes, Article 1 of the Constitution, which we incorporated treaties, we also said in that case, in those two cases, that the rulings of the Corte Interamericana de Derechos Humanos, the Inter-American Human Rights Court, are binding on federal judges in Mexico when Mexico was a party, and they are citable precedent, even if Mexico was not a party to the cases. So we very much read what the Inter-American Human Rights Court does. I know other countries in Latin America have taken the exact opposite step. And we do sit down and we do discuss these things and we do talk about these things. And there is a lot of reading of the other cases. So there's a lot of constitutional dialogue in Latin America, more than one would imagine.
Would you like to answer?
Hay que entender a México ahorita del México de hace 20 años.
You have to understand Mexico now from Mexico 20 years ago.
Hace 20 años teníamos la misma política de los Estados Unidos que no acepta que ningún tribunal internacional le diga nada.
20 years ago, we had the same policy as U.S. that doesn't accept that any international court can decide anything for the U.S.
Lo que nos comentaba nuestro amigo europeo de Hungría, de que cómo van a venir del extranjero a decirnos qué tenemos que hacer, es algo que estaba en el ADN de todos los jueces latinoamericanos.
Just as our European colleague was mentioning, how dare somebody from another country come and tell us what to do was definitely in the DNA of every Latin American judge.
Pero la apertura de los tribunales mexicanos y de la Suprema Corte en concreto todavía no es una batalla ganada.
We still haven't won the battle of opening the judges on the Supreme Court and the Supreme Court.
La resolución del ministro Alfredo Gutiérrez, que cita jurisprudencia de otros países, no es bien vista por todos los ministros.
Not all the justices see in good and favorable regard the decision of the justice to cite treaties, international treaties.
Pero yo creo que podemos aprender de la experiencia de otras naciones y de otros juzgadores.
But I think we can learn from the experience of other countries and other judges.
El conocimiento es universal y debemos de aprovecharlo.
Knowledge is universal and we need to use it.
And on that, I'd like us to thank Judge Sajó and the two justices and Cristina, and we'll move to